Okay. Go ahead.
You ready?
Yep. Hey, good morning, everybody. I'm glad you guys are here. Thank you so much for being online. We have a lot for you today, so I am not going to talk a whole lot. You can't see the floor, but I have been put into a box here, so I'm not allowed to get out of my box or I'll be out of the filming zone because it's just doing really. We got Abby over here running the gimbal today. If you have a question today, raise your hand. Abby will come to you and give you a microphone so that we get your recording on there and we have that on there for you. So that's going to happen today. We're very fortunate to have Olivia Lee, attorney, here with us today, who does estate planning. She's going to talk to you about trust versus wills and things of that nature and why they're so much more prolific and so much better for you and really kind of how to plan out your life and take care of those things in the afterlife, I guess you could say, right? So life, afterlife, right? But before we get started real quick, I just wanted to say I had a good leadership meeting this morning with everyone and me and Craig and Aaron and Abby, and we were just talking about the direction of the company. And there's so many good things happening right now. We have so many positive things that are coming about with just all of the different training that we have available this year and just amazing kind of things that are going down. Later today, I'm going to ask everybody, we're going to send out a thing. I'm going to ask everybody if you would. My book is coming out today on Kindle. We're having a special running on it. So Kindle will be 99 cents for the next week. So I need everybody, if you would, to go and buy one copy. If you do, I'll pay you your 99 cents back. But I need to get as many sales in the first week as we possibly can to try to hit that Amazon bestseller. So if you would, please just go to Amazon. I'll send out a link. Once it's live, I will send out a link for it today. And you guys can order that. It's called Accidental Real Estate. Short read, about 100 pages, little workbooks in there, but I think it'll be really, really good, beneficial for anybody really trying to run a business of any kind, kind of help keep you on track. So that is coming out today. I have one person I need to bring up, do a little commercial with real quick, and then we'll get started with Olivia. Carrie Williams, come on up. Carrie Williams is our in-house lender at Revolution Mortgage, and I'm going to be honest with you, she's doing a fantastic job. She is absolutely, she's been awarded, what are you, number 5 in the company right now, Revolution?
Yeah, number of units.
Yep, number of units. So that's pretty amazing. It's a national company, so she's only been with them about a year now, going on a year, and just killing. So also big awards for VHDA loans done here in Virginia. Matter of fact, you're going to the
Next month.
next month. Going to where are you going?
Richmond.
Richmond. No, I thought that's for the awards, but aren't you going on some kind of sales trip too? In the Caribbean?
Yeah, that's Bahamas.
Yep, there's that too. So Carrie Williams.
Just a quick market update. The market's doing okay this week. So we'll take what we can. There's been a lot of talk about inflation or the lack thereof because the main component right now is shelter costs, and the data that's pulled is like 9 to 12 months old. So it's really hard to judge and really get a true calculation on where we stand. So Barry Habib, he's a gentleman that I've been following for a decade. He's kind of the guru for mortgage-backed securities and mortgage, advice on where interest rates are going. I follow his commentary every day. He was actually asked by President Trump to put together sort of a summary of his thoughts on where the economy is, to present it to the Fed, because Trump's view is that we need to start reducing the Fed funds rate. We are in a better position. The problem is like I said, the data that's used and collected is oftentimes wrong and old. So you're really not looking at the current information. So we'll see how that transpires. The Fed is their own entity. It is kind of good to have the separation of church and state, but they also beat to their own drum sometimes for good or bad. Also, too, just want to bring up community lending financing. So there is a program through Chase that's offered, and it's for homes that are listed in underserved markets, is the correct terminology. So what my team is going to start doing is that every month we're going to be looking at where the listings that your office brings on. And if we find that one of your listings falls in that designated area, then we'll reach out to you to give you some details on things that you can do to market the property. What it means is that if a borrower is getting a conventional loan, if you think about it, I'm sure you've heard the term LLPAs, loan level price adjusters. Those are those incremental changes to the interest rate based on their credit score, their down payment, and the type of property. So very common now because of these harsher LLPAs, if the borrower has a 720 credit score and they're only putting down 3%, it doesn't make sense to go conventional. They end up going FHA because the interest rate is so much higher. Well, with this program, it wipes out those LLPAs. So they get a much better interest rate. They can go conventional, which has better mortgage insurance that falls off eventually, yada, 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 right? So, like I said, if you have buyer or if you have listings, I've looked on the map, majority of it is going to be like Norfolk, Hampton, Newport News, Portsmouth, parts of Suffolk, very few pockets of neighborhoods in Virginia Beach, very few pockets of neighborhoods in Chesapeake. But again, we're going to kind of try to start on a regular basis, keeping track of what listings are coming up, because I think it's just another talking point, another way that you can advertise the property. I can provide you some flyers for it, and it's for conventional buyers.
Can we check with their team before we do a listing presentation for an address?
Absolutely, yeah, you can just absolutely just. I mean, I can send you guys the map. So if you even just wanted to,
They update that.
it's pretty much set.
Oh.
Yes, because it's set by regions.
Okay.
So, but yeah, I could
So
send
not
that to
weekly
you.
or anything.
No. So I could just send you if you wanted to, I could send you the map.
Send it out. We'll put it in the Broken Library.
Yeah, you can type
For
in
the next couple of weeks, let's get a slide up for that. So send me what you would want to say about that slide, and we'll get a slide up for that just so we can remind.
Sounds good.
Great.
So that's it for today. Thanks.
Thanks, Tara. Appreciate it. Terry does a great job personally for that. There's so much going on. I'm excited for the new year. So, but without further ado, Olivia Lee.
Thanks, sir.
Thank you. Hey, Mike, you up here. All right, here's that. You have the floor.
All right. And I am so happy to be here, especially in the new year, because this is something that we can check off our to-do list is planning. So, all right, so we'll get my
Show me it's pulled up.
slideshow here, but because this is something that a lot of people have to learn the hard way, and I want you guys to learn the easy way. So, all right. So first, my agenda. There we go. Okay, so first, we'll do first a little bit about me, very short, and because I'm not the word snare, and then also we'll jump into what I call the foundation of what should be in an estate plan, and then I want to dive into some very specific scenarios that are relevant for realtors specifically. So I pulled some out that you guys are the first line of defense for, that I'm not going to see because you guys see them first, and you're going to be able to say, hey, red flag here, and be able to spot those issues. So, all right. So first, a little bit about me. I went to work for some of the bigger law firms in the area, and then just recently, this last year, went out on my own. And I wanted to point out a couple of things. When you hire an estate planning attorney, I want you to look for 3 things. One, you want to make sure that they focus in on estate planning, that they're not a general practitioner, that they do, criminal law on the side, and then they do medical malpractice claims, and then estate planning on the side. Okay. Because estate planning is very detailed, and if they just do a will on the side every now and then, they're not going to be able to advise you correctly. And I have seen some of those wills that they do by an attorney that border on malpractice because they have included certain provisions. So just be very careful that they focus in on that. And second of all, you also want them to also be specialized in elder law. So estate planning and elder law are actually 2 different types of law. But elder law, also, you'll get the benefit of asset protection planning too, because estate planning is often focused more on tax planning, but with elder law, you'll also get the benefit of asset protection from long-term care costs and things of that nature. And another thing is that a lot of estate planning attorneys, what will happen is you'll find that their first 20 years in the business. They were off doing litigation and things of that nature, and they got burnt out, and then they decided to do estate planning. So you want to make sure that they actually have some experience, and even though they look like they have a lot of experience in the field, they might not, because they were off doing some other type of field for the first 20 years of their career. So first of all, what is estate planning? It's a very vague term. I didn't even know what it was until I actually went to law school and studied for it. So estate planning is essentially planning for incapacity and death when you really dial it in. Okay, but it's also planning for incapacity and asset distribution and asset protection. And one thing that I like to point out is that this is more than just documents. Okay, documents are a byproduct of what we do, but it's actually through counseling that we get to a better result, because you can get DIY documents online, but if you don't know what to put into them or the right questions to ask, honestly, there are a number of reasons not to do it, but one of the reasons is that you don't know what to ask and you don't know the right questions to answer. So show of hands, does anybody have an idea of what the most important estate planning document is? Does anybody have an idea? Throw out some answers. Yes. No wrong answers. There are no wrong answers.
It's trust agreement, right?
Trust agreement. Okay, that trust agreement is one answer. So some might say a will. But a lot of estate planning attorneys argue the power of attorney. And that's because this is while you're still living, and it will avoid guardianship. So this document appoints the person to handle your affairs while you're still living and during incapacity. Okay. And this avoids, usually guardianship can cost up to $8,000 while you're still living if you can't sign a power of attorney document. And there are a couple of things to look out for. There are two types. There's a medical and a financial. You want to make sure that you have both. And you want to make sure that it's durable. Sometimes it won't be durable. If you're looking at DIY documents, they won't be durable. Durable means that it's still effective when you're incapacitated. And you'd think that sort of defeats the purpose. Well, of course, it needs to be durable. And springing versus immediate. So another reason why DIY is not great is because a lot of people will make their documents immediately not immediately effective. They'll think, I only want it to be effective when I'm incapacitated. But there's a lot of red tape for it to spring into effectiveness at that point. So who determines incapacity, right, at that time? So you'll have to get a sign off from a doctor to actually say that you're incapacitated. And oftentimes the doctor doesn't want to say that you're incapacitated. It's a liability for them. So that's going to be some red tape. And so you want it to be effective immediately and not a springing power of attorney. And some people have qualms about that. And if they do have qualms about it, sometimes I question, do you actually trust the person that you're naming? And so you want to back up and make sure that you trust that person implicitly. Because I had one client who he named the person that he thought would be the most reasonable. And I asked him, do you trust this person? And he said, oh, absolutely not. And I was like, okay, let's back up here. We need to rethink about who we're asking to do this. So, and another thing, I have audited hundreds of powers of attorneys. Okay. I have only seen one that has the correct estate asset protection provisions in it. Only one, even the ones drafted by other attorneys. And this is because I also do elder law, and we handle a lot of the asset protection cases. And if we don't have that provision in order to move assets around and put them into asset protection trusts and things of that nature, then we have to go again to guardianship just for that one provision. Could cost us $8,000. And then also another thing that I see when auditing powers of attorney is I'll open up their power of attorney and they'll only have one person listed. We want a really deep bench when we are listing our agents, because what if they're unavailable, or they're incapacitated, or they're traveling, some reason they're not available. We want to have a really deep bench, because again, if we don't have that person, again, it's back to guardianship. And I put change of beneficiary designations as something to look out for too, because I use it as an example that DIY documents are again a bad idea because when you go through the powers, you're checking off the powers to include in your power of attorney and your agent that your agent can have. And it says, do you want them to be able to change beneficiary designations on your accounts, like bank accounts, life insurance, things of that nature? You're like, no, I don't want them to change who I have listed on those accounts. I've done that for a reason. Well, there are a number of reasons why we might want to let them. It puts flexibility in the plan. What if that beneficiary has deceased and the next person in line is a minor child? And that would force the assets to go through probate. What if that person is disabled and now on government benefits and they inherit those assets? They're kicked off government benefits. So there are a number of reasons why we want to build in flexibility. And again, another reason why we want to trust that person that we're putting in as power of attorney agent. All right, and then a couple of power. So if you're a realtor and you have if you're doing a closing with an agent acting under power of attorney, you want to have that in the format. Make sure they're not signing as under their own name. It's as agent for the principal. And also do not attempt to determine somebody's capacity to sign. So just because somebody has an Alzheimer's diagnosis or a dementia diagnosis does not mean that they don't have capacity to sign. So a lawyer can determine whether or not they have capacity because they can still be lucid and understand the powers that they're giving away, even if they have some of those diagnoses. We don't want to go straight to guardianship. We want to avoid guardianship at all costs because it's incredibly expensive. One other thing to include in the incapacity planning. So again, this is so important because you're still alive when these documents come into play. And the advanced medical directive, that's the one that gives permission to be taken off artificial life support if there's no chance of recovery. And it's different than a DNR. A DNR is something only a doctor can put into place when you're in the hospital. But an advanced medical directive should be done beforehand. And it really does take a huge emotional burden off of your family because it's a really hard decision to make, especially in an emotionally charged situation. And I just wanted to point out that these documents are a moot point if we don't have access to them. So one way to do that is there is a service called DocuBank where you can upload all of your medical legal documents and they give you a card, and your doctors and your healthcare facilities anywhere in the world can access those documents. And so, because I'm an attorney and I don't carry those documents around, so I certainly don't expect other people to, but if they don't have access to them, then the doctors are not going to know who to talk to or who they are allowed to talk to. So what happens without POA? So we talked about guardianship. One thing I just wanted to point out is there was this one scenario. Oh, sorry. I'm sorry if I bumped the microphone. There was this one scenario where it's as soon as somebody turns 18, they're considered an adult, and parents lose the access to all of their records. So one time the parents got a call from their college kid's roommate. Roommate said, "Hey, you get down here, your kid's in the hospital." Parents called the hospital. Hospital can't talk to parents because the kid's unconscious and can't say, "Yes, these are my parents. They're okay to talk to." Parents drive several hours to the hospital. They just have to wait at the lobby until the kid is conscious. Can't talk to any. Well, the billing department will talk to them. The billing department will always talk to them, but they can't find out anything about the kid. So as soon as somebody turns 18, and they're like, sign power of attorney and advanced medical directive and HIPAA authorization, like the day of, because otherwise there could be serious consequences later. Luckily, that turned out the kid did become conscious, but it was a harrowing experience for parents, for the parent. And I also had a scenario where an adult daughter had a mother in the hospital with a trach and could not communicate any needs. And we were going through guardianship, and guardianship takes a long time. And sometimes decisions need to be made immediately. And unfortunately, before that, she passed away like the night before the hearing. And so all that time she wasn't able to make medical decisions for her mom. And so it's just reiterating again how important these are during our lifetime, because we think, oh, I'm not going to need that until it doesn't matter. Estate planning is just after I pass away. But if you have nothing else, powers of attorney. Those are my go-to. Okay. So I feel like it's intuitive on what is an estate, but what we're really talking about is focusing on real estate today, but just note that intellectual property and digital accounts are also in crypto. Those are also part of the estate, so make sure that people have access to those because more and more people are having less physical statements online and having more and more digital. So making sure that they have access to digital accounts is really important these days. So even if somebody has a will, title is always going to override the will. Okay, so we have to make sure that, again, it's reason why we want to have a cohesive plan is because we want to make sure that they are thinking that we have one plan and then really things are going to go the other way. So title always trumps. So we can have things owned individually, jointly, or by contract. And by contract is life insurance or 401k, things of that nature that have a beneficiary designation on it. And those beneficiary designations are also going to override a will. So this is really important for realtors. I'm not sure if any of you, sorry if you're already aware of this, but you can own realty in a number of different ways. Jointly, tenants in common is one, and you can have unequal shares, so one can own 40% and another can own 60%, and there's no right of survival. There's no survivorship rights. If somebody passes away, it's going to go down to their heirs. And joint with rights of survivorship, it automatically passes to the survivor. So again, that's going to trump a will. So even if you think, oh, I have 50% rights in this property and your will says all of my property goes to my kid, whoever owns the property is going to get it, not the kid. And then tenants by the entirety is exclusively for married couples, and it provides easy protection from individual creditors. We call it poor man's asset protection because married couples can put them in as assets or tenants by the entirety and have protection from individual creditors. And so it's a really easy way to just throw in some asset protection. But the risk with relying on jointly owned assets is that it only avoids probate for the first person to pass away, because people say, oh, everything I own is going to go to my spouse, it's fine, but we're only delaying probate until the second person passes away. And okay, so let's see. Oh, and have any of you heard of the transfer on death deed? Yes. So there aren't I rarely ever use it. There aren't much uses for it in Virginia because Medicaid doesn't offer very much protections in Virginia. Each state is different. There are other states that it could be more advantageous, but oftentimes it's just more money. There are better ways to plan than a transfer on death deed in Virginia. It's different in other states, and the risk with beneficiary designations that by contract is what we said earlier of it going to a person under 18 is going to be forced to go through the probate process, and it has no rules. So if it's a minor, it's going to go outright to the person at 18 with no instructions or rules. You can't have any control over that.
What happens, so it's automatically going to go to the heir if they're under 18, they're minor. Who gets to control it?
The court decides, so it's forced to go through their estate. And so the court decides.
So the other parent if they're separated or divorced.
Mm-hmm. Yeah, it could be.
Essentially your ex is controlling it.
Yeah, your ex could end up in control. It depends on who the judge is going to put into. If you didn't choose somebody, the judge is going to decide who gets to control those assets. Yep, exactly right. Okay, so is this something that realtors ask their clients if they have an estate plan? Do you ever know how many of your clients have an estate plan?
Not
usually. Okay. My argument is that they all have one because the state has a plan for them. If they die without a will or any type of planning, there is an intestacy law that decides who their assets go to. It's not always who they want it to go to. So really estate planning is opting out of the state's plan for you. And their plan for you is kids do get inheritance outright. And a judge who, if there's no will, there's no guardian nominations, and so a judge will decide who raises the children. And a judge is like you just said, a judge will decide who's in control of the money. And probate court is almost guaranteed. And if you're married and the spouse remarries, this actually happened in my own family with my grandparents, where the grandparent remarried and changed the estate plan to the new spouse and completely disinherited his old family. So there's always a chance of that. And that happened in his 70s. So don't tell me it can't that there's never a chance of it happening. So, okay, but the alternatives is either a will or a trust are some of the main options. And a last will and testament is better than nothing. And it does not, you always have a last will and testament. If you have a trust, there's always a will to go with it. So it will nominate the guardians for your children. And it will nominate an executor to help you wrap up your affairs as well. But where a will fails is that, of course, it goes through that probate process and it doesn't provide for incapacity. Like we said, those are the powers of attorney documents, and it doesn't provide for incapacity like a trust may either. And you don't get to write the instructions for the assets. You don't get to say how or when the assets get distributed. It's just outright to the people listed in the will. And like I said, it's not during your life or for the lives of their surviving spouses or children. It's just it's just has control over that short little window of time during the administration, and then it's done. And we like to say where there's a will, there's a probate, which is often the case. But what is probate? I often get wrapped up in saying probate a lot, and it's this vague concept, but really it's the court process of the assets transferring from the decedent to the heirs. And the court appoints the executor, and they'll publish notice in the papers for creditors if you request it. But you also have to inventory and appraise everything. And the soonest that you can submit your initial accounting to the Commissioner of Accounts for approval is 6 months. So it's going to be a minimum of 6 months. It often takes, I've seen it usually take at least a year to several years, even for shockingly quote unquote simple estates. And you often have to hire an lawyer to get through it.
And during that time, you can't touch the assets.
No.
So like if grandma has 50,000 sitting in the bank, you can't touch it to pay her bills that are still going on. Or
So she'll have administrative bills and things of that nature. So the executor or the person in charge has the authority to come in and close everything out and pay the final bills and things of that nature. Or
if there's a mortgage.
So yeah, they'd be able to come in and
Utilities, things like that.
to enough to settle everything and shut everything down. And if they're going to sell the house, they have the right to go ahead and sell the house and things of that nature. But they would be able to use the funds for the expenses to settle out the estate.
You know, some wording on the slide before you put that your will nominates an executor. And here you put the court appoints an executor.
Yes, good point. So a will nomination just nominates it, but they have to go actually to the court to get the court stamp of approval and give them letters of authority.
Can the court say, no, not that guy, and appoint someone else?
Not unless they have a reason to.
Okay.
Or something disputed.
Well, I assume,
yeah.
Claim of fraud or something.
Yeah,
like
there's well, an example of they would have to have a good reason to. But otherwise, because they have to come in, hopefully they have a original will that names them first. But if, for example, the first person listed, there would have to be a reason of them being unavailable or incapacitated or them predeceased for them to not use the first person listed. But yes, nomination versus court appointed, they do have to do that extra step. And then warning, I just want to make sure that if you have clients who have property in different states, maybe they have rentals in one state and they live in another, and there isn't planning involved, they will have multiple probates. Okay, and that's just nightmare upon nightmare. So and it will eat up 2 to 8% of the estate. That's very, very true, because you'll have probate taxes, you'll have attorney's fees, you'll have filing fees, which are dependent on the size of the estate. So it quickly adds up. And like I said, it's very time consuming. It's at minimum of 9 months. Like I said, you have minimum, you have that 6 month, which is the soonest you can file, and it frequently takes a year or more. Oh, and another fun thing is everything goes on public record. So a will is on public record. Anybody can go down and look at it, but also all of the inventories and the accountings go on public record too, so they can see what you owned and where it went. So some people, they don't care about that, but for some people that's really important. So I want to point that out as well. And this is just a sample estate that I threw together just to show an example of that, how expensive a probate could be. So if we have in real estate 500,000, we've got stocks 250, and life insurance, if it's payable to a minor, is going to be forced through the estate, even though it's a beneficiary designation. So if both spouses passed away and they listed their minor child as the contingent beneficiary, it's going to be pushed through the estate and going to go through probate. And so if the 401k is also payable to a minor at 50 and we have a total of 1.8 million, then at conservatively it's at 2%. Like Brenda said, it was 2 to 8%. We're looking at $36,000 in just probate. And I promise you, any estate plan is going to be cheaper than $36,000. So a will-based plan is appropriate though if the estate is less than 50,000. Virginia does have a small state act that's the cutoff threshold. If you have $50,000 or less in your estate, not including real estate, then you can get away with a small state act affidavit, okay, to claim the real estate. But if it's over 50,000, you have to go through that formal probate process. And another thing you have to guarantee with the will plan is you have to guarantee that no minor children are involved and that no disabled beneficiaries are involved. And I don't have a crystal ball, so it's really hard to guarantee that it would be the case at somebody's death.
So you're saying that would be for someone who has like little to nothing in their name.
And you want to guarantee that no minor kids are involved and no
So
disabled.
if you have like an aunt who's really just living off Social Security and lives in an apartment, she probably doesn't need to do much because it's going to fall under.
Right.
30,000.
Yeah, and it doesn't include real estate. So they could have a $300,000 home, and then if they only have like the only thing that they have is 20,000 in the bank and a $10,000 car and some personal assets around the home, then they're probably not going to need anything else other than a will because it falls under that 50,000 threshold. So yeah. All right. Okay. But a better option in most cases is going to be the revocable living trust. And basically it is a will on steroids. And honestly, it has become the new will in the past decade or so because it has become more accessible to everybody and people are realizing that it's important to avoid probate and you can put instructions in it. And so we name beneficiaries for your assets in the trust, and the trust is revocable. You can change or amend this at any time. So it's not like it's set in stone. So people have this fear that they're going to lose control over their assets, but really you are not going to notice that you have a trust once everything is set into place. And while you're alive, you're actually the trustee. So you have full control over everything. So right now, everything is outside of your trust, but you have to move everything into your trusts by retitling them. And like I said, but even though it's retitled into your name as trustee under the trust, you still retain control and your taxes don't change. There are no maintenance fees while you're still living. You're the one that is handling the trust. So a trust is an agreement that spells out the rules that you want followed for the assets when you pass away. So it's an agreement between three parties, a grantor, a trustee, and a beneficiary. But while you're alive, you're all three. So you don't have to answer to anybody to use your own assets because you're all three. When you pass away, you nominate a trustee to take over the assets when you pass away, and you determine who the beneficiaries are. And so, especially over this past decade, we have gotten over this idea that trusts are only for the rich. It's less, and people have asked me, okay, what's the threshold that I need a trust? And it is less about a threshold and more about your goal. Like I said, if you have a minor child involved and you only have, let's say John has $100,000 in a bank account that he wants to put instructions on, his son Sam can only get it if he's 25 and has graduated from college, then he needs a trust. So it's not millions and millions of dollars, but if he wants to put instructions in, he's going to need a trust in order to do that. So the retitling, it's so expensive to, or it's so important to retitle the assets because otherwise you just have an expensive stack of papers. The trust has to be given control over the assets. So this is how, for example, you would retitle a deed for retitling a deed into a revocable living trust for a couple. So you would retitle it to spouse one and spouse two trustees, and I'm just making up the name to the trust. The legacy living trust dated blank, either of whom may act independently. So it's still in their names, but it's in their names as trustees versus in their names individually. And one note, in order to maintain that creditor protection of a tenants by the entirety, you want to make sure that it is first placed in both of the spouse's names and then placed into the revocable trust. I've had to do double deed operations where we put it first into the tenants by the entirety and then into the revocable trust because it was only in the husband's name and we wanted to capture that asset protection. Well, you're first going to have to go first into both of their names and then into the trust in order to retain that asset protection. All right, and again, the trust solves all of the problems that come with that will. You won't lose the 2 to 8%, and it can be the time frame can be compressed into weeks instead of months. It really just depends on how long it takes to consolidate the finances, and you're just waiting on the financial institutions, but you don't have any deadlines from the court. So you don't have to get approval from the commissioner of accounts or do any accountings for him, which is amazing. And it's totally private. Like we said, the will goes on public record and all of your assets go on public record. Trust is completely private. There's nobody that has to have access to it other than the beneficiaries. And we even give you a summary of the trust that has the most important information on it to give to financial institutions to prove the existence of the trust so that they don't have to see the whole thing.
Lenders won't take the whole trust, we just take the cliff notes, because oftentimes it's got information that.
Yeah, it's not anybody's business but your own. So we give you, it's usually called a certification of trust that you will give them instead of the, plus you don't want to give them 60, 70 page document. All right, so the other benefits of a trust is that it is easily changed. You can amend it at any time and it's valid in every state. So even if you move, you don't have to start from scratch. You don't have to retitle everything into a new trust. And it's a lot harder to attack than a will is. It's easier to attack a will maybe for undue influence or things of that nature, but it's harder to attack a trust because a trust involves a lot more planning. So in order to have that much astuteness to do that type of planning, it's difficult to say, oh, they didn't have undue influence. And then it's not a separate tax entity. So like I said, it doesn't change anything for your taxes. So it's very easy to maintain. And there are no like maintenance fees or anything while you're still living. And it's actually really nice because it creates one document to organize all of your finances. So you don't have to, if you decide, oh, I want to change who gets 50% of the assets, you don't have to go through all 20 of your financial accounts to change the beneficiary. You can just go into your trust, who already has control over all of those assets, and change it that way. So you don't have to go through all 20 financial institutions again. So I throw this in there here just to show the most common revocable living trust structure. This up here is actually, the top one is while you're still living, and the revocable living trust is then changes to a marital trust when the first spouse passes away. And the red line is only optional in case there is an estate tax exemption. I don't know what it's going to be when you pass away because it changes with every administration. So there's a built-in family trust that only pops up in case the spouse disclaims some of the property and wants to take advantage of an estate tax exemption. Okay, most people are not going to get there. Right now, it's 13.9 million at the moment, so most people are not going to make it. but we always put it
You can
in.
only hope.
It's a good problem to have.
First world.
It's a
Yeah.
good problem to have.
Elite first world problems.
But we always put it in there, even if you're below, because during our lifetime, it has been 1 million. So even though it's unlikely to go back down, we just don't know what it's going to be. So we build that in to protect it. All right, and so there are a number of ways to give to the kids outright. So a lot of people will have a couple different options. So we've got outright and lifetime asset protection trust, where you keep them in trust for their lifetime. And you might want to do this if they have a high risk profession, maybe they're a doctor or an architect or a lawyer, and you want to protect the assets for them. And since it's created by a third party, there's built-in asset protection for them. But one of the most common is actually ages and stages, where they'll say, okay, I want a third to go at 25, half at 30, and then the balance at 35. So it's staggered. And the child can learn how to handle the assets over a period of time. But it doesn't mean that they don't have access to the assets prior to it. They can still go to the trustee and say, I have a medical emergency, or anything for health, education, maintenance, and support, which is a broad category. So they are not going to be left high and dry if something does happen, because people get worried that they're not going to be able to access funds if they need it.
Who is normally a trustee?
So you get to pick.
If both spouses are.
If both spouses are passed away. So people usually will pick a family member, whether that be a sibling or aunt or uncle or I also often recommend a corporate trustee. So it could be another law firm. I stay away from banks because they have a lot of red tape and they're very big and they don't have very personal touch. But there are, for example, there's a law firm in the area that I always recommend. So it depends. Some people have somebody in their lives that they absolutely implicitly trust, but if you don't, I recommend, usually there's a law firm, Legacy Fiduciary Services, that's what they do. And so it just depends on the situation. But there are options regardless. All right, and then, okay, so switching gears a little bit, and this is the last part of before real estate issue spotting. So this is where I am the most adamant about education, because I was in law for a few years and I saw how devastating long-term care costs can be because it is so expensive. And 70% of people have a chance of requiring long-term care services during their lifetime, and 56% have a chance of staying in a nursing home. And if you want a private room, the average cost is $10,000. So every month. So hopefully the best nursing home is the one we don't go to, but since we have such a high chance of going to one, we want to plan for it. And so I just put these numbers up here just to show that every year, and 22% are going to need 5+ years, because usually there's an Alzheimer's diagnosis and you're fine from the head down, and people keep on living, and people are living longer, and so it's becoming much more expensive. So every year it's $120,000+, and that can easily eat away at somebody's hard-earned assets that they've built up over their lifetime. And I also say this to it may not apply to you, but think about it for your parents too. Because my parents are aging, our parents are aging, and this is something that they need to be educated on as well. Because not only selfishly, because it's your inheritance going away, but also they'll be able to get better care as well if they're able to protect some of their assets.
So if their assets are in a trust, Medicaid can't touch it, is what you're saying?
So there's a special kind of trust.
Okay.
So there's a special Medicaid asset protection trust. And this is something that you wouldn't put into place when you're younger, because you do end up losing some control. And but you only usually it's a child and only a child. we want somebody who has that moral obligation to help the parents out, that have a moral obligation but not a legal obligation to help the parents out. And the reason is there's a back door to this type of trust because yes, they lose control. But there's a back door. They get to have a lifetime beneficiary of this trust, and they move those assets into that lifetime beneficiary's account, which usually is a child. And that child can do with it whatever they want at that point. Okay, the government doesn't care what they do with it. And so they can use, and again, they have that moral obligation to use it for mom and dad, but we don't have it documented on paper. Okay, so we want them to transfer assets into an asset protection trust for at least 5 years. And after that 5 years, those assets are no longer countable. And then you can get them qualified for Medicaid, which Medicaid only allows $2,000 in your name, which is laughable because it's absolutely nothing. So I have seen this type of trust, and I'm so passionate about this type of trust because I have seen this trust alone save people hundreds of thousands of dollars because of its asset protection capabilities. And it's especially helpful for people who cannot qualify for long-term care insurance or have waited too long to get long-term care insurance. This is another way to protect your assets and then qualify for Medicaid later. And again, this is a great strategy for if you have aging parents to keep this in mind as well. Oh, and I do warning, don't start Googling irrevocable trusts because you'll hear a lot of horror stories. They work wonderfully if you do them correctly with an attorney. But like I said, don't do research, don't do self-research on this one.
But there's so much great information on TikTok.
Yes, the internet's never wrong, right?
It's on the internet, it must be true.
TikToks.
Right. Okay, so I wanted to point out a few issues that realtors can spot. Have any of you had cases where a client wants to just put their kid on the deed? Just put their daughter or their son on the deed with them?
Yes.
You have?
Yeah.
It's a red, okay, yeah, a red flag for that because there are a number of reasons not to do that. I won't go through all of them because the biggest one is they're going to lose a step up in cost basis if they do that. When you inherit a piece of property, you actually get a step up in cost basis of the property. So you won't have to pay the capital gains on all the appreciation because mom and dad probably bought the house like back when the house was what, $15,000, and now it's $500,000. And so you don't want to pay capital gains on all of that appreciation. But if you get that during their lifetime, then you will have to pay capital gains on that if it's not a personal residence. So avoid that, and additionally avoid not only partial transfers, but this is also like full transfers between family members. They'll think that they're quote protecting it for Medicaid purposes, and they'll just transfer it to a child. But this will actually trigger a penalty for Medicaid because they're looking at transfers within the past 5 years. So it's better to avoid that. And plus, also, like we just said, we're losing that step up in cost basis. So we avoid that. Oh, and looking out for if you're dealing with a senior and the client loses capacity during a transaction, the best option is we have the property in a trust and the successor trustee can step in and complete the transaction, no problem. Second best is relying on a power of attorney. And the worst case scenarios, we would have to petition a court to complete the transfer because we would have to appoint a conservator to handle their finances. And another thing to point out is don't transfer, caveat, have them talk to an attorney before having a personal residence transferred into an LLC because they can lose protections and there's an increased risk of taxation if they do that. So we want to avoid retitling into an LLC. And if they already have it in there, also talk to an attorney before they remove it as well. And we touched on this earlier. So clients owning real estate in multiple states. So maybe they'll have rentals in one state and they live in another state and they don't have any planning in place. That's going to mean they have multiple probates. So I had this problem with my father-in-law. He had property in multiple probates. I'm like, oh my gosh, you've got to get something in place because we're going to have probate in all of these different states. And so if we and that just adds up cost wise because that probate can eat up 2%, 2 to 8% of the estate. And this one, so if clients, this is something that I'm not going to see because you all are the front line of people, seeing people move from other states to Virginia. If they move from a community property state and they're a couple, they have certain protections as a community property state that they might lose if they come to Virginia, which is a separate property state. And so before they move, they should talk to an attorney to discuss ways to preserve that community property status. And the community property states right now are listed right there. There are 9 of them. But if you Google community property states, it pops right up to make sure you're just keeping tabs on, okay, are these people coming from a community property state? Because again, they could lose some huge tax benefits. Okay, and I have seen an influx of this because parents are having to finance children's homes because millennials are no longer able to buy homes by themselves. And so the kids are having to get financed from the homes. But the problem is that this can trigger gift tax reporting. So they can gift and there might not be tax consequences, but it will trigger tax reporting, gift tax reporting at the bare minimum. So you need to be sure that if they're doing and they want to keep it private, I've had them I just want to keep it simple, it'll be fine, we'll just give them this money, but they actually have to do reporting along with that if it's over $18,000 of a gift. All right. And so finally, I just say that being proactive, it is best to have a properly drafted living trust with disability provisions and properly titled real estate in the name of the trust to ensure a smooth and efficient property transaction, even if the property owner dies or loses capacity during that transaction. So it will protect you as a real estate agent because you're not going to have to deal with the courts as well, having to step in to help complete a transfer or transaction. So I want to just act as a resource to you all. Okay, I know it's like drinking from a fire hydrant going through most of this, but I want to just be the continuing resource to you all because I'm very passionate about all of these topics, and I want to make sure that everybody in the community is able to understand these proactive planning methods. So thank you all for having me. I really appreciate it.
Thank you. Olivia, I met with her a little while back and she doesn't know yet, but she's actually going to do all of mine. And I think she does Carrie's. So if I could give her an endorsement, that would be the endorsement. Something that if I could give her an endorsement, it's probably the best endorsement. If you noticed, yeah, there's some things on here that none of us even think about. I have things I certainly wasn't thinking about. And you think you're young. You're not. Talking to you, Jack. So Olivia, thank you so much.
Thank you.
I appreciate it. Guys, I'm gonna let you get out of here early, man. Let me keep you here. I'm not gonna hassle you too much. Next week, we have a great class next week. Aaron Alford is going to be talking to us about due diligence and how to handle weird shit in real estate. And that's going to be talking about things like you don't run into every day. How do you deal with a house with asbestos? How do you deal with a house that's got lead-based paint and it's been found? How do you deal with a house that has got septic systems that are defunct? And we just don't deal with that all the time. So we're going to talk about you as a real estate agent doing your due diligence, being that professional that can answer those questions for people when they need and know what direction to send them. She's even, I think, going to talk about what do you do with raw land? What do you do with land that doesn't have any access for utilities? I mean, how do you build on it? What do you do? What's the first thing you have to do? Maybe she might even talk about an environmental one survey or a study, which takes core samples of the ground and then tells you what type of foundation that you can put a house or even if you can build a house on that piece of land. So all of these things, very, very important for you to know. You don't run into them all the time, but due diligence for weird shit in real estate. And that's exactly what we're gonna call it. So, I'm gonna open up for questions. Anybody have any questions? Any questions for Olivia? Yes, Rob, hold on. Here we go. There we go.
Earlier in the slide. Early in the presentation, you said, assets is, or the estates, not just real estate, it's like your stocks and stuff like that can go to your spouse. Does like doctor bills, debt go also?
And the other side of the other side of the other side of the coin. So debts, so that depends on what kind of debt we're talking about. Sometimes if it's credit cards, there are ways to avoid credit card debt, because it's an unsecured loan. And there are ways to do that. But there was a new law recently saying that you couldn't hold a spouse liable for their medical debt. So
Okay.
that is still in flux since it's such a new law. But there are protections in place of not straddling the surviving spouse with the medical debt, and there are certain ways to handle the other debt too.
Okay.
But of course, like with a mortgage and things that are gonna have a secured debt, you're not gonna be able to get out of because they have a lien
Gotcha.
on that.
All right, thank you.
I have a question up here. If a home is exempt from property taxes, does putting everything into a trust change that? It's a
Yeah.
great question.
Like if a senior.
Yeah, no, military. I'm 100% exempt from property tax right now.
Okay, so for a revocable living trust, that's not going to affect it. Because it's a see-through entity, so you're still considered the quote unquote owner. For an irrevocable trust, if you're going to do asset protection planning, you can't have, it depends on what kind of irrevocable trust. If it's considered we're getting into the nitty-gritty a little bit, but if it's considered quote a grantor trust, you should be able to get those exemptions still. If it's a non-grantor irrevocable trust, then you're probably not going to, but that might be.
Case by case basis.
Yeah.
Okay. Any other questions before we turn to anybody else have anything they'd like to ask?
You touched on this, you offer the, sorry, you may have touched on this, you offer the service as well to like change everything, because that's like the hardest part.
Oh, yes, yes.
Because like everything has changed, homeowners insurance, every
Yep.
401k, every bank account,
Mhm.
everything has to be changed,
Yep.
the name of the trust, right?
Yes, so I do, I help do most of it. I cannot impersonate you. So you will have to go to I can give you the paperwork and fill out the paperwork for you, and I do all of that. But I can't go to the bank for you and say that I'm you, but I will do everything up to that point.
Checklist of all the things. that have
Yes,
changed.
absolutely, 100%.
If you don't change it into the name, it's like as if it doesn't exist.
Right, so typically what we do is, for example, if there is a piece of property and say something happens before you're able to retitle it, let's say you had a plan done a couple years ago, but you get a new account or a new piece of property and it's not titled yet and something happens, we always do what we call a pour over will, and it will quote unquote scoop that property and place it into a trust, but it's not ideal. It's our spare tire. We hope we don't need it, but it's there in case we do. If that asset is big enough, it might trigger probate. But if it's under that 50,000, then we can use the Small State Act to pull it into the trust. Yeah.
So just to follow up to that, so a lot of attorneys may or may not guide you in doing the transition of everything. They'll provide basic guidance there. I've seen you provide like kind of a hand-holding guidance to make sure that the trust is
Right.
taken care of and properly funded.
Yeah.
Can you talk on that point?
Yeah, don't listen to him, that's your help.
That is.
What? Stack of the audience.
He does have a good haircut.
Softball. So yeah, it's true. A lot of estate planning attorneys will just hand you a letter and, you walk out the door with only a letter. But I can handhold you through that process. Absolutely.
Also, I'll say this, when you go through the interview process and filling out all the paperwork, you will list all of those things. There's all of that stuff that's listed out. So she will already know the stuff that you're going to need to change because you give her all of that information.
Another question, sorry. When it comes to real estate, what if you had real estate in LLCs? How is that impacted by a trust?
Right, so you wouldn't put, since the real estate is owned by the LLC, you wouldn't transfer the real estate, obviously, to the trust. You would transfer, if it made sense, you would, and there isn't something in the operating agreement with the LLC that it has already designated how it is going to be transferred at death, then we can transfer membership interests of the LLC into the trust, and you can then say in the trust, this is what happens to the LLC membership interests.
Let me add on to that. If we add to that just a little bit, there's a lot of real estate agents that have LLCs in which they run their business from. So could that LLC also be included in their trust, their business LLC?
100%. If they don't, again, if they don't have something already in, like, because you can do planning are in your LLC operating agreement and the other arrangements, buy-sell agreements and things of that nature that you can do separately. But if you want to do it, one option is to do it through the trust. You can assign those membership interests to the revocable living trust and then designate what happens to those interests.
Do we have any other questions? Because these are all good questions. Yes,
So
Aaron, hold on.
So you brought up the different states, and the trusts. And so if you have properties in multiple states that you own, where would you want to set up that trust? Does it matter? Can you set up in a different state than you live in, or should it be in the state that you live in?
yeah, so with the good one. So if you want a trust that lasts forever, like for generations, like you're talking Rockefeller style trust, then you want to be in specific states. But if you don't mind it lasting for 1 or 2 generations, then I recommend being in Virginia where you're located.
Now, what if the person is located in another state, but they own property here? Would it still be beneficial to be in that state?
Oh, yeah, wherever they're a resident of, it's so you're saying that the person who owns the property is in a different state.
Mhm.
So it would be best for them to have the trust be located in the state where they're residing.
What about cars?
Oh, cars are a pain because it's the DMV. So we actually, so a couple things,
Especially if they're paid.
if they're paid for. So one thing, we don't put them into trust for a couple, unless it's like an antique or a collection car that is really expensive and don't drive anymore. So one, personal injury lawyers are sharks. They're my friends. Oh crap, this is going on the internet. They're my friends. But they're my friends, but they are sharks. So we don't, if you get in a car accident, we don't like them to see that they're the quote trust, because when they see trust, they think money. So we don't typically put them because it's the same exact process of going to the DMV, whether or not it's in a trust. And so we just like, no, just leave it. Because the DMV is its own little world and they make you do the same thing anyway. So
What about guns?
So guns, it depends on the type of gun. If it's a NFA registered gun, then you're gonna typically want a special trust, a firearms trust for that. If it's not, and it's just, an heirloom from your grandfather that doesn't need to be registered, then typically you just put that inside of your revocable living trust, and then you can designate these guns go to my grandson.
Same with jewelry, expensive jewelry, things like that.
Yes, same with jewelry, things of that nature. You can even, and I don't expect anybody to have all of that. Like when they meet with me, I don't expect them to know all of that, but I do give them, the law allows us to add on a personal property memorandum that you can, as you go along, be like, oh, I want that ring to go to, my niece or whatnot. Then you can list that in the personal property memorandum. You cannot do that with anything else. Don't try to do this with bank accounts or cash or anything else, just items around the house. But the law recognizes that you don't want to come to the attorney every time you get your wife a necklace.
So that's something you can follow yourself. Okay.
Yep.
Great. Any other questions? Now's the time. Awesome. Thank you so much. I had an ovation on that one. I had to bring her back up here. Encore presentation. Softballing in from her question from her husband back there, so that worked out pretty good. All right, guys, I'm gonna let you go. Thank you so much for being here. This has been a great class. Olivia, thank you for being here. Everybody, great questions. Now, as always, get out there and sell a house.